Okay, I think we'll get started. So I assume people will continue to trickle in. So hello, everyone. I'm Karen Price. I work at the Vermont Family Network. Welcome to our Back to School Time to Understand COVID and CompEd, or Compensatory Education Services workshop today with Rachel Seelig, staff attorney at the Disability Law Project at Vermont Legal Aid. All of our workshops, including our previous ones, are recorded and can be watched on our VFN YouTube channel. The link is on our website, which is vermontfamilynetwork.org. Everyone who registered for today's workshop will receive a follow-up email with a link to this recording and a PDF of the presentation with live links. So Vermont Family Network has been serving families of children with special health needs and disabilities and the professionals who serve them for more than 30 years. We are the federally designated Parent Training and Information Center, the Family to Family Health Information Center, and the Vermont chapter of both Family Voices and Parent to Parent USA. Today's workshop is being recorded, so please keep that in mind as you share information about your situation in the chat. These sessions will include live captions. If you want to turn them off, click on Live Transcript, then Hide Subtitle. If you're comfortable, you are welcome to turn on your camera. You can ask questions using the chat box, which you'll see at the bottom of your screen. Please feel free to share information or links to resources that you found helpful in the chat as well. We can all learn a lot from each other. So I'm excited to introduce you to Rachel Seelig. Thank you so much for joining us today.
Thanks so much for having me. I'm excited to be here. Let me go ahead and start sharing my screen and we'll get started. So we did call today's web workshop Back to School, Time to Understand COVID and CompEd, or Compensatory Education Services. My goal for all of you today is to make sure that you know your rights when it comes to the IDEA, or Individuals with Disabilities Education Act, understand what we mean when we're talking about a free and appropriate public education, or FAPE, learn what compensatory education is, understand the kind of guidance that both the federal government and the state have put out around CompEd, and for you to be able to make a plan to ask for what your child needs, whether that's a CompEd services or just amendment to their IEP because things are not going as you would have expected. So it's hard because of how much we've been through over the last 18 months to think about sitting down and looking at the IEP at the same time we're getting back to school, and some of our schools have already had to close for periods of time, or classrooms. And so we know that this is still a really difficult time, but it's an important time to sit down with your child's IEP, both so you can focus on moving forward and so that you can look back and have the history of especially the last 18 months inform how to move forward. So on the left-hand side of your screen, we have some of the questions that we often ask about IEPs to make sure that the IEP is doing what it needs to do. It's important that present levels of performance are accurate. We often see IEPs where the information provided is from the last comprehensive evaluation of the student. But if IEP goals are being tracked and progress is being monitored, there should be additional information about where your student is at the time the IEP is being rewritten, to let everyone on the team know what the baseline is that we're now moving forward from. Looking at goals, you want to make sure that goals can be measured in a way that the whole team can sit down and look at the information that's been collected and understand what it means in terms of your students' progress. And goals should also be challenging and relevant. Goals should not be so simple that a student can achieve them in a month, but they also shouldn't be so difficult or so disconnected from what your students' abilities are that they aren't in any way relevant to where your student is or where they're hoping to get to in the next year. And it's also a good time to look at that services page, look at the amount, the duration, the type of provider, that's providing the special education and related services. Sometimes we're looking for consistency. We know that what's happened in the past has been working and we want to keep that going. Other times we're looking for change. We're looking for change because what happened in the last year or year and a half wasn't effective. And so we want to see change to something else that will work better. Or a student has made the progress we were hoping they would make, and so they may need less services. We may be able to pull back some of that special education or related services. But in order to answer some of those questions, we also have to look back. We have to look back because we need to know if progress wasn't made in order to adjust the IEP to handle that. We also need to understand the progress that was achieved and make sure that those goals are still appropriate, relevant, and challenging. And especially because the last year and a half has been so difficult and services have been provided differently and we've lost staff at our schools, we also need to understand the progress that the student made in light of what services were actually able to be provided. And the reason that we are asking, I think we lost a slide here. The reason we're asking to think about this right now is because when we talk about some of the rights that you have, one of the rights that you have is to file an administrative complaint, but that can only go back for 1 year. And you have the right to file for due process and ask for a hearing officer to look at your child's case. But that can only look back at 2 years from the date that you knew or should have known that a violation had occurred. And so because we're more than a year past the start of the pandemic, because we are approaching 2 years of education looking very different in our state, it's an important time to be able to assess where your student is with FAPE, because you don't want to miss out on those dispute resolution options if you need them. So before we jump into those options, again, one of the things I wanted everyone to leave today knowing are some of your key rights under the IDEA, or the Individuals with Disabilities Education Act. When teams come together, you're often coming together to talk about changes to the IEP. And they may be changes that everyone else on the team, all of the teachers, the principal, the special educator, the related services personnel all want to make. That doesn't mean you need to agree. And if you don't think the changes that are being proposed are right for your student, you have the right to, and you should, state your disagreement with what the team is talking about. When that happens, if the team can't come to consensus, can't get every single member of the team agreeing with the same plan, then the LEA, the local education agency's representative, gets to make a decision. But they need to then give you that decision in writing in a prior written notice. And so it's important for you to voice your disagreement, whether you say so and make sure it's recorded in the minutes, or whether it's after a meeting or before a meeting in writing, so that you have that record and you get that prior written notice. And that prior written notice becomes important in the dispute resolution options we'll talk about in a minute. Another really important right, and one that's really kind of key right now in thinking about asking for comp ed, is your right to request an IEP meeting and for that meeting to be scheduled within a reasonable time, which is generally 30 school days or less. You also have the right to ask for additional services and supports, including assistive technology, that may be needed in order for your student to receive that free and appropriate public education. When you have team meetings, you have the right for all team members to be present, and for folks to miss meetings only if you are agreeing that they are not necessary for the discussions that are going to happen, and agreeing in writing. This is really important because if we're looking at, are the present levels of performance accurate in thinking about the goals, the progress that's been made, if you're missing someone who has key information about those present levels or about that progress, that makes it really hard for the team to come together and make informed decisions about changes to the IEP or about comp ed. As I said, you have the right to prior written notice before changes are made, in particular when you have made clear that you disagree with a decision, but really any time that the IEP is going to be changed. You should get notice of that before the change goes into effect. And every student who has the right to an IEP has a right to what is really an individualized education program. And so decisions about what the student is going to receive in terms of services and supports and accommodations and what their goals are going to be needs to be based on the individual need, not based on any blanket policies or programs that the school has kind of out of the box. If you feel like these rights have been violated, or if you feel like your student has not been able to receive their free appropriate public education, then you can use dispute resolution options. And those include mediation, due process, and administrative complaints. Mediation is a process where you bring in a neutral third party. And this is a voluntary process. So both sides, both the family and the school district, need to agree to it. But you bring in a neutral third party to help you try and come up with a resolution to disagreements. What's nice about this process is it's confidential. So what you discuss during mediation stays in the mediation. And you also can walk away. If you're not getting what you need to in order to resolve the disagreement, you don't have to agree to anything. So that's one option. An administrative complaint is a process where you write down what you think the district has done that's wrong, that's violated the rules, that has made your child not able to receive their free appropriate public education. And you send it to the Agency of Education and ask for them to do an investigation. They have 60 days to do that investigation and send you back a report about whether the things that you raised for them, they found to actually be violations and what needs to happen to remedy violations that they did find. And the third major dispute resolution option is a due process hearing, which is like going to court over a special education dispute, except you hear the case in front of a hearing officer instead of a judge. But otherwise, it's very similar. There's sharing of evidence between the two sides. There are days set aside for trial, and then there is a decision by that hearing officer. Now, these options are not mutually exclusive. You could just file an administrative complaint, or you could start with mediation, walk away because you're not getting what you need, and file an administrative complaint. You can file an administrative complaint and find that you didn't get the outcome you wanted and bring the case to a hearing officer. Or you could start with mediation, walk away, and then file for due process. Or you could start with an administrative complaint. And rather than having a hearing office, having the Agency of Education finish a report, you could resolve the things you raised in the administrative complaint through mediation. You can even file for due process and then try and mediate to resolve the things you filed about instead of having the hearing officer make a decision. The only thing you can't do is take a case to due process, lose, and then raise those same exact issues in an administrative complaint. So these are all options, and you can use multiple options to try and solve the same problem. So here we are. So why now? Why are we talking about all of this now? Why are we talking about Comp Ed now? Well, there are these deadlines. For administrative complaints, it's 1 year. For due process complaints, it's 2 years. And because of how far we are into the pandemic, we don't want folks losing their opportunity to pursue these dispute resolution remedies if they can't get Comp Ed through the IEP team process. So in order to talk about Comp Ed, first we have to talk about FAPE. FAPE, again, is free appropriate public education, and it refers to the special education and related services that are provided at public expense, meeting the standards of a state education agency, complying with an IEP and the requirements of the IDEA. And I've also got on the screen here for you the definitions of special education and related services. Now, part of FAPE is really easy to understand, the free part, right? Free means it should not be costing the family money. And the public education part, I think, is usually pretty easy to understand too. That means that the education that's being provided to the child is being provided by your local education agency, whether that's because your student is in a public school or because the local education agency or the school district is paying for your student to be placed elsewhere. The part that can be tricky is what is appropriate. And unfortunately, Congress didn't help us out by defining appropriate. And so we've had to go to the courts to get clarity about what we mean by appropriate. And there are two major Supreme Court cases that help us understand this concept of appropriate. The first one was decided all the way back in 1982. It's called the Rowley case. And in that case, there was a child who was in the regular classroom, but the family was asking for additional services to be provided. And what the court decided was that appropriate means that an IEP is conferring some educational benefit. And that, in her case, was understood to mean that she was being able to pass her classes and advance from grade to grade with the services being provided in the IEP. Now, that concept of some educational benefit was left pretty vague, and over the years, different courts in different parts of the country interpreted it differently. And finally, it came back to the United States Supreme Court in another very famous decision called Andrew F. And in that case, the court clarified that some educational benefit does not mean any little tiny bit of educational benefit. It needs to be more than that. But there's still not a requirement that students on IEPs get the ideal education or an education that maximizes their potential, which was the hope of the folks who were advocating in that case. That case was different, though, than the earlier case, the Rowley case, because the student in that case was not in a general education classroom. And it really didn't seem like that was a reasonable prospect for that student. And so what the court said is in situations like that, where being in the general education classroom is not a reasonable prospect, the IEP, to meet that appropriate standard, needs to be reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. The court recognized that's a very fact-intensive exercise, and it needs to involve not just the teachers, but the parents as well. And it needs to set out a plan to pursue both academic and functional achievement. The court also said that goals in an IEP need to be appropriately ambitious, just as passing grades and advancing from grade to grade is appropriately ambitious for students in a regular classroom. So we have these two poles now of students who are in the regular classroom and that Rowley standard of passing grades and moving on to the next grade level. And we have the Andrew F standard for students who are not in the regular classroom of goals that are appropriately ambitious and reasonably calculated to enable progress academically and functionally. Just as passing grades is appropriate for students who are in the general ed classroom. So that's the standard that we're talking about when we talk about FAPE. And there's obviously a lot in the middle. Most students are not 100% in the general classroom or 100% out of the general classroom. And so there remains a lot of, I think the legal word is squishiness when it comes to what's appropriate. But we do have some guidelines here, right? Because one of the standards is that IEPs are implemented as planned. And so when IEPs can't be implemented as planned, that is one piece of evidence that would suggest that FAPE was not able to be provided. Comp Ed is a remedy for when FAPE can't be provided. It's additional instruction and services to which a student with a disability may be entitled to make up for any skills that might have been lost if it is individually determined that the student was unable to receive a FAPE. Now, historically, we've talked about this in the context of a family having filed due process and having had a hearing officer decide or a court decide that the student didn't receive FAPE, that they were denied a FAPE. But in the context of the COVID-19 pandemic, we also have to think about this not in any kind of menacing way or that a school was being purposeful or intentional in not providing a FAPE, but the reality of a really difficult situation that we've all been in, and that even with best efforts, sometimes buildings had to be closed. Sometimes there were other disruptions of services. Sometimes it wasn't safe for a student to return to in-person learning, and the nature of their disability made remote learning impossible. And so for those students who could not receive a FAPE, not necessarily because anyone wasn't trying in the context of a pandemic, Comp Ed is a way of making up for what was not able to be provided. What you have up here on the screen is a definition of Comp Ed that has been provided by the U.S. Department of Education in their Ed COVID-19 Handbook. And there is a link later on in this presentation to that handbook. And this definition, if you like page numbers, is on page 24. The Agency of Education here in Vermont has provided a slightly different explanation of comp ed that I do want to share with you as well. They describe this as a remedy created by judges and hearing officers as one form of legal remedy when there has been a denial of FAPE under IDEA. It can come in many forms, but it's commonly understood as an offer to make up for certain services that were not provided as outlined in the student's IEP. So that's a slightly different explanation. And the reason I have this one up on the screen really is because I think this one is better at understanding this, not so much as a denial of FAPE, but as the reality of a difficult situation and the inability in some cases to provide that FAPE. But I do like that this explanation talks about skills that may have been lost, and our Agency of Education explanation talks about services that were not able to be provided as outlined. So these aren't, in my view, super different. And I think when you look at them together, they give us a couple good questions to think about in asking for comp ed. So another key piece to understand in thinking about asking for comp ed is that Congress did not change special education law when the pandemic hit. That means all those key elements of IDEA stayed in place. And so students still had a right to FAPE, still had a right to an IEP, still had a right to be educated in their least restrictive environment appropriate to the student, still had a right to evaluation. Parents and students still had a right to participate in the IEP process. The procedural safeguards remained in effect and confidentiality remained in effect. So if any of those pieces, not just FAPE, but failure to provide an IEP or moving a student out of their least restrictive environment or not evaluating or not appropriately evaluating, those might also be reasons that comp ed might be needed because those all remained in and continue to remain in effect during this pandemic. Over and over, federal guidance has also made clear that IEP teams and 504 teams need to meet to address the need for comp ed. Back in March of 2020, March 12th, before our schools in Vermont even closed, the U.S. Department of Education issued guidance saying that when schools reopened, they needed to make every effort to fully implement the existing IEP or 504 plan, and that teams would need to meet to decide whether comp ed was needed following a school closure or for any extended period of time where a child did not receive services. An extended period of time is generally understood to mean more than 10 consecutive school days. And this slide also has a link to that document if you'd like to see it when you get the slides from VFN after we finish today. More recently, in May of this year, U.S. Department of Education put out another guidance document of frequently asked questions about how all of this money that's coming from Washington can be spent. Just so you know, there have been 3 different laws that have passed that have sent extra money through 2 programs, the Elementary and Secondary School Emergency Relief Program and the Governor's Emergency Education Relief Program to the states. So back in March of 2020, the CARES Act sent money. Then in December of 2020, there was a supplemental appropriations bill that sent more money to our state. And then most recently in March of this year, the American Rescue Plan Act sent even more money to our state. And in answering questions for states and for districts about how that money can be spent, one of the things that was identified was for students on IEPs, compensatory services to address loss of instructional time either because of a school closure or other disruptions in services because of the pandemic. And they also said the money can be used for 504 students to make up for skills lost. So again, here we have loss of instructional time and loss of skills because of the pandemic as reasons that a team should be considering providing compensatory education and that there's federal funding to help pay for that compensatory education. Then just earlier this summer, the U.S. Department of Education issued yet another document. Again, there's a link if you'd like to see it, called the Ed COVID-19 Handbook. I referred to this one a little bit earlier. And this one is really helpful for a couple of reasons. The first is it makes clear that if schools or districts are doing school-wide or district-wide interventions to address the loss of instructional time that occurred when schools closed in 2020 or during the last school year, students with disabilities need to be included in those school-wide or district-wide interventions. But that's not all. Again, the U.S. Department of Education said districts also have the responsibility to make individualized decisions about needed services for students with disabilities, which may include additional instruction and services to make up for any lost skills if the student was unable to receive FAPE because of COVID closures or disruptions. So over and over and over again, the federal government has been saying we got to have meetings and we've got to figure out what comp ed is needed. So when I look at all of these different documents, and there are even more, but I thought maybe 3 would be enough for us today, I came up with some key questions to think about in considering whether you think your child might need comp ed and whether to ask for it. One question is, were any of those key elements of IDEA delayed or denied because of COVID? Was the IEP delayed? Were the evaluations delayed? Were services delayed? Was your student not in their least restrictive environment? Were you not able to participate in the IEP process? Those would be reasons to think about asking for comp ed. Was the IEP not fully implemented when schools did reopen? Were there, even after schools reopened, extended periods of time where services were not provided because of COVID? I know that tremendous efforts were made to come up with in-person learning plans, hybrid learning plans, remote learning plans. Efforts were made to get access to the internet to families who haven't been able to have it. Packets of work went out. Lots of things happened over the last year and a half to try and make things work during COVID. But for some families, things still did not work. And so there may be families who, for more than 10 days, had a student who wasn't able to access services because of COVID. That's another reason to ask for comp ed. Another reason to ask would be because of loss of skills, because of school closures or delays in services. Another reason, lost instructional time. And last, and this one is more procedural, if the team has not met already to make an individualized determination of the need to make up for losses that have been identified, that really needs to happen. And if the team won't meet or met, but you weren't satisfied with the outcome, you can pursue mediation or due process or an admin complaint to try and get a better outcome for your student. And these really shouldn't be thought of as big deals. This is what Congress put in place for us as ways to resolve when families and school districts don't see eye to eye. Now, in addition to all that federal guidance, the Vermont Agency of Education last fall put out a guidance document to think about how we address losses of learning because of COVID or lack of progress because of COVID. And what they advised was that IEPs should all be re-examined to look at lack of access to general education, episodes of ineffective access to special education, issues of the appropriateness of an IEP after a change in delivery service model. So for example, for some students, changing to a remote model was just not appropriate. Progress monitoring that indicates a lack of progress or even loss of skills, and recognizing that districts continued to have and continue to have a responsibility to provide FAPE. The guidance went on to say that what might be needed to make up for that would be things like remediation, an increase in existing services, or even new services, as well as potentially amending the IEP to address lack of progress either in IEP goals or in general education. And one thing that's really important is to understand that that was not a new obligation of districts. It has always been required that if a student doesn't make progress in goals or in general education, that the team needs to look at the IEP and revise it to try and remedy that lack of progress and do better moving forward. So a little bit more on what this guidance document had to say. reasons that comp ed might be appropriate would be that the offer of FAPE was not appropriate to the student. For example, remote learning, not appropriate to certain students because of their disability. Or there was a lack of sufficient core instruction or quality or quantity of special education and related services. Another reason that FAPE might not have been able to be provided was that because of the student's disability or because of technological or logistical problems, the student was just unable to access IEP services that were offered remotely. One area where the agency's guidance says comp ed would not be appropriate would be if a FAPE offer was appropriate, it was effective, it was accessible, but the student was not able to make progress or even demonstrated regression. But we're going to talk in a moment about what the agency said to do in a situation like that anyway. So in order to think about figuring out comp ed, some timeframes were provided. It was anticipated back in September of 2020 that it would probably take up to 12 weeks after returning to school to identify regression from the school closures from March on in 2020. And it was hoped at that time that the COVID-19 impacts on education could be addressed over the next 12 months. So essentially between September of last year and now. But the agency recognized that there would be a variety of factors that could impact that, including whether the pandemic continued, which obviously we know it did. And so what we have been hearing is that not all teams were able to identify regression or have meetings about regression or need for comp ed last year. And so those meetings may still need to be happening this year. The guidance also told districts that they need to document determinations they've made about student progress and objectives, and to use the Form 7, that official form of letting you know if there's a prior written notice of a decision, if there's not agreement. And they also emphasized that there needed to be patient and parent and caregiver information and consultation in making determinations about student progress. And then they came up with this multi-step process in order to decide if a student needed comp ed or something else. The first step is data collection. And data collection can look like curriculum-based progress monitoring. It can look like input from family. It can look like tests or assessments. And then the districts were advised to put that information into an understandable format for everyone on the IEP team and schedule a team meeting to review the data. And as a team, to look at that information and decide, was FAPE able to be provided or not? What was the impact of COVID? And what does the data show about the students' needs now? And what they said is that if the student's needs or the student's lack of progress or the student's regression or learning loss was because of the inability to provide FAPE, the appropriate remedy would be compensatory education services. Those services might be provided in the regular school day, over school breaks, in intensive targeted programs, or by bringing in outside providers. They also, though, said that there may be some situations where a FAPE was offered, a FAPE was provided, but the student still didn't make the progress we wanted from them, or the student regressed. And in that case, comp ed, compensatory education services, wouldn't be appropriate, but they identified this other category of supplemental services, such as online or in-person tutoring, facilitated social skills opportunities, contracted services in the home setting. Very similar things to things that might be identified to be provided as comp ed. So really the upshot here was whether a student didn't make progress because they were denied FAPE or because they didn't make progress or regressed for some other reason, the team still needed to come up with a way to remedy the student's deficits. So again, if the deficit was a result of the loss of FAPE or denial of FAPE, comp ed would be the way to go. And the team would need to talk about and decide upon what kind of compensatory measures would be needed to correct the failure to provide FAPE or the inability to provide FAPE, and what would restore the student's educational benefit. And again, compensatory education is very flexible. So for a student whose primary needs are around reading and math, it might very well be additional reading and math tutoring or after-school services. For a student whose primary need is around social cognition or social skills development, it might be facilitating social skills work. On the other hand, if the student's deficits that are identified by looking at data did not show that there was a loss or denial of FAPE, that didn't mean that there wasn't more to do. It was still important to examine services and progress and decide how to correct deficits. And in both cases, whether there's a loss of FAPE or denial of FAPE or not, the third step is, as you can see here, to confirm by amending the IEP to reflect either the compensatory services or the supplemental services to be provided to get the student where we want them to go. Now, I know it has been a long 18 months, and we are all feeling a lot of different feelings, and it can be hard to add one more ask, one more set of meetings, one more set of after-school activities onto our calendars. But it's part of what we do to make sure our students get what they need. So here's the process that I suggest to folks. If you feel like, having listened to what I've been saying for the last few minutes, like your student might need comp ed or might need changes to their IEP, request an IEP team meeting. It's one of the first things I mentioned, right? You have the right to request an IEP meeting at any time and for it to be scheduled in a reasonable time. That's generally 30 school days or less. You also can provide input on what the agenda should be. So here are some of my suggestions. You want to review your child's progress. You want to assess their need for changes to the IEP in light of lack of progress or in light of progress. You also want to assess the need for compensatory education following this guidance that the Agency of Education put out for all of us. And you want the team to decide on compensatory education. If you're not able to resolve by meeting with the IEP team, or if you can't get the IEP team to meet, Vermont Family Network is certainly here and available as a resource to you, and so is legal aid. You can call us, you can tell us what's happened with your student over the last year and a half or longer, and we'll give you advice about whether we think filing an admin complaint or requesting mediation or filing due process makes sense. And if it does, there are certainly times where we can help you do that. We can also give you advice about whether we think what you're asking for in comp ed makes sense, or if it's too much, or if it's not too much. And we can give you advice about continuing to try and work with your IEP team if you feel like that is still an option that you have. But we also do encourage you to consider filing admin complaints, because it's one of the ways the Agency of Education can become aware of whether there are districts across our state who didn't follow the guidance about scheduling meetings to talk about comp ed for each IEP team that exists in their district. And for them to recognize whether there really is kind of a broader need for them to get involved to make sure that all students get the education that they are entitled to. Filing an admin complaint does not need to be super hard. They don't have to be long. All you need to is identify what areas of what's been going on you have a problem with. You explain what you've tried to do already and explain what you want to kind of fix the situation. On the right side of the screen here, I have 3 paragraphs, really 3 sentences that could be the substantive part of an admin complaint. The rest of it really is just filling in who you are, who your child is, what school they go to, and what their disability category is. But in terms of the substantive, like where you have to fill in and explain what's been going on, here's an example. Parent requested an IEP meeting to ask whether their child could get comp ed services to make up for service interruptions last school year when she was sent home several times because of COVID exposures at school. It's been more than 30 days since she asked for the meeting, and she had been told they couldn't meet because they didn't know, they hadn't collected the data to understand if she'd been impacted by those periods of being sent home or not. And the way that she thinks this could be fixed would be for money for 2 months of tutoring, because those periods of time where her child was sent home meant that she missed 10 45-minute sessions of special education and reading. And that during that time, her child made no progress on her goals and lost skills over those 2 weeks. So three paragraphs, 3 sentences can kind of summarize what it is you want the agency to look into and investigate on your behalf. And now we'll pause and ask if there are some questions that I can answer about this topic. I know we got a couple ahead of time, but I see Karen, you're back up. And what you got?
Right, I am back up, and I just want to remind listeners that DLP came up with a couple of templates that are on our website or to help parents file administrative complaints. There's one for compensatory services and another one for delay of evaluation, special education evaluation. And it makes it extremely easy to file those administrative complaints. But yes, let me go through a couple of the questions that we have received. I would encourage anyone else who has questions, put them in the chat. I'll read them out for Rachel, so we can all hear the questions as well as her answers. So one of the questions, does Comp Ed apply to a child who attended private school for the last 2 years, entered public school this year?
Probably not. The PE in FAPE, the public education, means that it's being provided by your local education agency. And so if you have chosen to unilaterally put your student into a private school, during that time, they didn't have a right to FAPE. And so there's no inability or failure to provide FAPE. The exception to that, though, would be if your school district placed your child in that private school as their placement for their IEP. And then even if they were attending that private school, because it's being provided by that local education agency, then the question of Comp Ed would still apply.
Yeah, okay. What should one do when a school says they cannot find a tutor for Homebound Study and Vermont VLC, which is the Vermont Learning, I've forgotten what it stands for. It's the
Virtual Learning Collaborative,
yes. Is not an appropriate alternative.
So that's a really tricky situation, because what that probably means is that the whole team has agreed that the student cannot be educated in a place with their peers, probably because of a medical reason. And that's why they're on a homebound program. And if no tutor can be found, then what that's telling me is probably the student is receiving no services. And so they're not receiving their free appropriate public education. And so I think there are a couple different things that can be done. One is, again, starting with the IEP team. If they can't find a tutor, can they give you funding to find your own tutor if you've identified someone? Can they connect you with some other contractor who could provide the services if they can't find a tutor? But if none of that problem solving is working within the IEP team, that's when these options of dispute resolution, whether it's mediation or an admin complaint or due process, become really important. And I think if you filed a due process complaint that said my child is homebound and getting no services, that would be a pretty clear, I don't think my child is getting FAPE argument for the agency to investigate. And then they would decide what the remedy needs to be, whether it is giving you money, whether it is changing your child's program in some way, working with the team. So if a student is receiving no services, that's definitely a good time to call VFN or Vermont Legal Aid to get advice about what next steps make sense in that situation. We don't want students out of school and getting no services.
Thanks, Rachel. Then we have one on transportation issues. I think it's Pulteney to Manchester, Vermont, and back.
So I can't really speak specifically to that trip. I'm sure that's a tough trip. But what I can say is this: if transportation is a related service, and so if a student needs transportation in order to access their special education, and that special education in order to access the general education curriculum, transportation needs to be provided by the school district. If the transportation isn't being provided or for some reason can't be provided, that is evidence that the child is not receiving their FAPE because they're not getting the services that are necessary for them, that are either in their IEP or that are necessary in order for them to access the services in their IEP. And so again, that's a good thing to bring up to the Agency of Education through an admin complaint or by mediating or even potentially with due process. Because that is transportation can be a major barrier to accessing the services that a student needs to receive their FAPE.
Thanks. So I have another question. Do you have any advice for families who feel hesitant to file a complaint? Families are often fearful the school will be mad at them.
Yeah, I understand those fears. And I think that sometimes in the short term, personal feelings might be a little hurt. But I think one of the things to think about is that it's not personal with necessarily you saying this staff person was bad, right? This is really about saying, I get that there were huge systemic challenges over the last year and a half in getting students what they needed. And I've tried to work with my team to solve this problem, and it hasn't worked. And the law says, this is what my remedy is, and this is what my right is, and this is what my responsibility is to my child when things aren't working the way they need to work. I would also say, to some extent, if your child's not getting what they need from the school, maybe it's good that the school will be mad at you for standing up for what your student needs. But mostly what I would say is, I think most districts understand that using dispute resolution is part of the process, and they don't take it personally. And they recognize that this is one of the things that is just part of the system that we have. And those procedural protections and those dispute resolution options were put in there because Congress knew that we weren't always going to get along and we weren't always going to agree about what's right for every student. And I think the more that families agree to file complaints and get outcomes from the agency, the less of a big deal it will feel for the next family and the family after that, because it will just become a much more normal part of the process. I hope that's helpful.
And Rachel, do you have any idea how many administrative complaints the Agency of Education does receive a year?
Not very many, unfortunately. Sometimes it's as few as 10. Sometimes it's more like 30 or 40. And I'd love to see it be more if there are these kinds of issues that need to be raised because they're not getting resolved at the school or the district level. So yeah, no, admin complaints are, what's nice again is they're not your burden, right? You just say what you think has gone wrong and then the agency investigates. They might talk to you, they might interview you, but they're the ones who are going to go through files and interview staff at the school and all that sort of thing. So it really is kind of a low barrier way of getting some oversight from the agency. And it's their job to provide that oversight. They are required by federal law to do general monitoring and supervision, and admin complaints are part of that. And so if they don't hear that there are problems, they don't know what they need to be looking for.
And Rachel, what if a school does not follow what the Agency of Education has ordered as a remedy? Then,
if they don't follow what the agency has ordered as a remedy, the first thing I would do is call the investigator who wrote the report and tell them that they're not following and ask for them to call the district and explain that, in fact, they are required to do what was ordered as the remedy. And if the agency can't do that, although I think they can and they will, that's another good time to call us about enforcing those decisions through due process or in some other way.
okay, are there any other questions that anyone would like to ask? I think people can unmute themselves.
Yeah, please do. We're not a huge group today, so I know it's being recorded, but it's okay to share yourself.
Okay, well, hearing no more questions for now. Thank you, Rachel, so much for today's informative workshop. Else, you will see a link to an evaluation in the chat. Please take a few minutes to complete it so we can make improvements and fulfill our grant requirements. We have many more interesting workshops coming up, and you can find details about those on the homepage of our website, which is vermontfamilynetwork.org, along with the links of the previously recorded ones. We have tons of information on our website, and getting connected to us is easy. You can follow us on Facebook or join our closed Facebook pages if you are a parent. The name of one of the closed Facebook pages is Vermont Families of Children with Special Health Care Needs. And the other one is the Vermont Families of Adults with Disabilities or Special Health Needs. You can also sign up for a monthly e-news or check out our YouTube channel. And
Is it possible to ask another question?
was there another question?
Yes.
Sure.
Go ahead. I have a question. We have a situation where the school has not provided homebound study for our children, and now they're claiming, even though they started to try to find a tutor at the beginning of the year and then could not, they're now claiming they did not know that they needed to provide homebound study, even though they had a letter from the doctor and the children are on a 504. They're saying that, you know, does that exempt them from having to have had to provide homebound studies?
So I think one of the challenges in a situation like that, I'm going to start with, even if there's a letter from a doctor, the 504 or IEP team needs to meet and agree on the placement. And so I don't know from what you're describing if that happened or didn't happen, but that could impact what a district's responsibilities or a school's responsibilities may or may not be. It sounds like it's a kind of a live situation. And so I think what I would mostly encourage you to do is reach out through our intake line that's up on the slide here to get some individualized advice about your specific situation. And I'm sorry you're going through that. That's hard.
Any other last questions for Rachel? So remember, we're here to help you as well at the Vermont Family Network, and Rachel has put their contact information up on the screen. So thank you again, everyone, and have a great day.
Thanks, Karen.
Bye-bye.
Bye, everyone.